It's time for IP in the news. And today we're going to be talking about trademarks, one of our favorite subjects. And there's a dispute going on right now in St. Louis between two stores. One is a Goodwill.
Thrift store.
What?
A thrift store.
A thrift store, right. I was going to say something else, but it's a thrift store and it's called Found by the Pound. And another store that is an upscale urban apparel store, and their name is Found Fashion. And so Found Fashion opened, and the people who went to the thrift store, Found by the Pound, were confused between their store and the other store. And so Found by the Pound got upset and they filed a lawsuit against Found Fashion, hoping that they could stop Found Fashion or force them to change their name.
They did, however, reach out to Found Fashion first, Found by the Pound did, and tried to settle it outside of getting the lawyers involved and were ignored. So
Right.
if you get one of these letters or somebody reaches out to you, you should really try to settle it as soon as you can without any pain or as little pain as possible.
Well, I guess they were just hoping that the Found by the Pound people would go away, but they decided not to do that. And there's a couple of interesting parts about this. First of all, Found by the Pound doesn't have a trademark. So they're trying to enforce rights in their name under common law rights, which is always a challenge. If you want to enforce your brand, you're better off having a trademark.
Right.
And so I think that's really the lesson here too, is if you get a cease and desist letter, respond to it, because sometimes you can work these things out. By not responding, they probably provoked the lawsuit.
Right. And this is in St. Louis. They're both in St. Louis, and I don't know if they ship across state lines, but would it work for them just to have a state trademark, or do you think they would need a federal trademark?
Well, you're always in a better position if you have a federally registered mark. You do have to have interstate commerce. Oftentimes, that's an easy test to pass, especially in St. Louis, being so close to Illinois. If you have customers, from different states, that often works. But yeah, that would definitely be a consideration, and maybe they couldn't qualify for a federal trademark.
Well, that's true. But I do want to say one thing, since we are talking about intellectual property, I do want to give credit to the source where we got this article from.
Yes.
So I found this on riverfronttimes.com, and it was written by Ryan Kroll. So if you want to know more about it, you can reach out to them on their website. But also, if you want to learn more about trademarks, you can go to learnmoreabouttrademarks.com and download a white paper that talks about trademarks, or you can call Gearhart Law and talk to Richard.
Absolutely. So now it's time for Richard's roundtable. And I guess the question here is, what do you think of this situation? Number one. Number two, would you be confused between the words Found by the Pound and Found Fashion? Dr. Gladden, welcome to the show. So good to have you here.
Oh, thanks. Yeah.
Please give us your words of wisdom on this topic.
I don't know. For me, I would be confused, quite honestly. I mean, I don't shop that much, right? So if I was looking for a clothing store that said Found something or other, I might end up at the wrong shop. So I think there is some confusion there, just as I heard about, the description of what you're saying. We have a number of trademarks in our practice, as well as patents and other things. So we've been very conscientious about trademarking things that we think are valuable to us. And, their name obviously is very valuable to them. It's their whole marketing tool, and really is kind of an innuendo of what's in the shop, right? So, in that sense, I would think it'd be important to them. I think it's a little bit of negligent on their part not to have gone down the path of getting a trademark for it. That being said, I can understand why their consternation, and they're still trying to protect themselves. It always impresses me that people are, the found clothing people, that they just take such a arrogant sort of approach. I don't know. It just seems, I wish the word was a little more cooperative, right? And so that's a little bit disheartening to hear that people can't just sit down and figure something out. But
yeah, I agree. I think that sometimes people react out of defensiveness, and they're like, oh, you're going to challenge me. And they think if they don't say anything, the problem's going to go away.
Mhm.
but it doesn't usually work that way.
Right.
So thank you for your comments. Kenya, what do you think about all this?
Well, truth be told, I only heard a portion of the first part, so I'll try to be as eloquent as possible. But yeah, I think when it comes to a lot of marketing and branding, if there's too much similarity in the name, it's definitely going to create confusion, especially with something so similar to this specific name. And I think, you know, when you come up with something great as far as a tagline and a title, like you should obviously protect yourself, but in the same sense, it doesn't give you liberty to steal from others in order to, you know, make your brand expand and be more relevant. So yeah, that's my 2 cents.
Well, that's
Wow.
appreciated. I think, you make a good point in that sometimes, especially with smaller retail stores or chains, they don't really think about the trademark issue and they don't do a trademark search. They don't really investigate. And they may not even get the opinion of an attorney if they find something that's close, right? So maybe if the found fashion people had, investigated a little bit more, they would have maybe chosen a slightly different name, or they would have at least been prepared for a challenge from the found
But
by
if
the
they,
pound people.
but no, if they did a trademark search, found by the pound was not trademarked. So they would have had to do an internet search.
Well,
So-
I mentioned do an investigation. So one of
Right.
the things that's, if you're opening a retail shop, one of the things you can do is just do an internet search of businesses, within a 50-mile radius, just to see if there's anything similar. But we don't know what happened, right? We only know that there's these two marks and there's a lawsuit pending.
So I guess you can buy lots of clothes in St. Louis.
We only know what we know.
That's right. Jodi, welcome to the show. Any
Thank
thoughts
you.
about this?
Yeah, it's sort of business 101, right? When you first start your business, you think about what am I going to name it? And then from there, you start your search. You look up websites, you do trademark searching. I mean, obviously, Found by the Pound, to your point, did not trademark it. But to your point as well, looking at proximity and so forth, your name is important, your brand is important, and you want to covet that. So I think, unfortunately, Found by the Pound was short-sighted in not trademarking. I think that would have obviously created more boundaries and bumpers for them. But Found Fashion, short-sighted as well in terms of not really doing their due diligence, because your name is only as valuable as you create those boundaries around it. So, and to your point as well, it's unfortunate that they couldn't try to resolve this and communicate with each other, because there might have been some small tweaks that each of them could have made to be able to compromise and allow each other to have their own lanes. Because, in trademarking, as you know, your lane matters, and they are both in fashion. So that does leave room for confusion.
Absolutely.
Yeah, well said. And what I found kind of surprising, but maybe it's not surprising to everybody, is that there was actual confusion. So there were people who were going into Found by the Pound thinking it was Found Fashion, and there were people going into Found Fashion who were thinking it was Found by the Pound. So
Yeah, could you imagine thinking you're going into Found by the Pound and you're going to Found? Oh my gosh, $200 for a used
right,
sweater?
you're thinking you're going in to a thrift store and you're getting this high-end price tag. So like, what's going on here?
So yeah.
Absolutely. So Zoe, welcome to the show. What do you think?
Thank you very much for having me. I actually have a question for you. I mean, because in Europe, I'm speaking from England, if you haven't really registered your trademark, then you really wouldn't have a leg to stand on. And because found is a normal word in the language, and it's essentially a past tense of a verb, to find. And I think we have a number of brands which use find something or other. Are there any other brands in the US which have a precursor of the word found?
I can't, that's a wonderful
That's a good
question. I
question.
can't really think of anything off the top of my head. Can you?
Not that I buy, but there probably are. We
There
just don't know
probably
them.
is, but
But if they're in a different classification, maybe it would be okay.
But you raised an interesting point. Found is a pretty common word, right? And so
Yeah.
why would you even be able to trademark that, or why would you think of it? But the fact is that trademarks exist not only in terms of their name, but also in association with the goods or services that go with them. So, for example, Apple Computer or Apple can be trademarked for use with computers, even though Apple is a common name. So it's kind of the same principle that applies to Found.
I mean, I agree with Jodi in the sense it is sort of principle 101, and what you're calling your brand or your name of your store is fundamental and critical, that you have some form of ability to not only protect it, but hopefully be unique. And you mentioned Apple with regard to computers. You know, we were meticulous about, careful about our trademark, and not only in areas where we thought we might want to go to. And as you well know, it's based on not just having the trademark, but in what particular classes and groups.
Absolutely.
Right.
And so that's really very critical. And the other point that you made was a good one too, in that in Europe, it is different. It's more of a registration system. And in the US, it's based on common law. And so you get common law rights in the mark through using it. And so even though Britain is a common law country, they switched over to registration principles similar to the rest of Europe. But in the United States, you still get trademark rights simply by using the word in commerce in connection with the goods that you have. So,
and while we're talking about this, just because you're trademarked in one country doesn't mean you get the rights in another country. So if you
Exactly.
want it, so for you selling Rockster, you're probably trademarked both in the US and in England, right?
And in China and in a number of different countries, yes, and regions.
yeah.
Mm-hmm.
Well, this has been a great discussion. I guess the takeaway from all of this is trademark when you can. And if you'd like to learn more about trademarking and the process, you can go to learnmoreabouttrademarks.com and you can download some information about trademarks, or you can book a consultation with me, Richard Gearhart, and I'd be happy to explain the process to you.